Physician-assisted suicide. Many countries have adopted laws that support physician-assisted suicide, the most recent being Canada. In February 2015, the Supreme Court of Canada struck down the ban on physician-assisted suicide, citing that the Criminal Code Section 241B, aiding and abetting someone to commit suicide, denies people with irreversible severe conditions their right to life, liberty, and security of the person as per Section 7 of the Canadian Charter of Rights and Freedoms. It was also found to violate Section 15, Equality Rights of the Physically Disabled. The debate involving the legalization of physician-assisted suicide has been playing out for decades in Canadian courtrooms. The most famous case that challenged the Criminal Code of Canada's law against suicide assistance up until the Carter case was that of Sue Rodriguez. She argued that this law violated her constitutional rights of personal liberty and autonomy. In 1993, her arguments for the right to choose how to die were rejected by the court by a ruling of 5-4. The court favored society's responsibility for the preservation of life and the protection of the vulnerable over Ms. Rodriguez's personal rights set forth in the Charter of Rights and Freedoms. In June of 2012, the Gloria Taylor case challenged assisted suicide legislation, and British Columbia's Supreme Court ruled that the legislation banning assisted suicide breached Section 15 of Canada's Charter of Rights and Freedoms, which states every individual is equal before and under the law and has the right to the equal protection and equal benefit of the law without discrimination, and in particular, without discrimination based on race, national or ethnic origin, color, religion, sex, age, or mental or physical disability. The Supreme Court of BC ruled that the federal government needed to write new legislation regarding the suicide law to reflect Canadians' human rights, as indicated in the Constitution. They argued that the current laws not only discriminate against those with physical disabilities who may need help to take their own life, but also deprives those with degenerative illnesses of their liberty. The federal government appealed this ruling in the BC Court of Appeals, and the ruling was overturned in March of 2013. In Quebec, however, Bill 52, an act respecting end-of-life care, was brought forth in June of 2013. This bill passed in June of 2014, making Quebec the first province to legally allow terminally ill residents the right to end their lives as they chose. Quebec's Bill 52 is an act that respects end-of-life care. Medical aid in dying is addressed in Chapter 4, Division 2 of this act. There is a specific criteria set out in the section as to who can seek medical aid in dying. The person must be of full age, be capable of giving consent to care, and be an insured person within the meaning of the Health Insurance Act, suffer from an incurable serious illness, suffer from an advanced state of irreversible decline in capability, and suffer from constant and unbearable physical or psychological pain, which cannot be relieved in a manner the person deems tolerable. The matter of health care is left to provincial legislation. Bill 52 makes it legal for people residing in Quebec who have provincial health insurance to seek and receive end-of-life care, including medical aid in dying. The physician's obligations and legal implications under this legislation state that the physician does not have an obligation to participate in medically assisted death, but has the responsibility to transfer the care of that patient to another physician to enable the request. Any physician who does participate in medically aided dying are not held civilly liable. This bill is to come into force in December of 2015. Now, in Carter v. Canada, the Supreme Court of Canada ruled in favor of the appellant. Patient autonomy has been long protected by the law in medical decision-making. In order to come to a determination in Carter v. Canada, many previous cases that set precedent were cited. In Fleming v. Reed, the judge ruled that even if there are serious risks or consequences, death included, that stem from the individual's decision, medical determination remains the right of that person. The same principle was cited in cases that dealt with the right to refuse to consent to medical treatment, as in the case of Cirillo versus Schachter, or with the withdrawal or discontinuation of treatment as seen in Millet versus Shulman. These cases solidified the importance of patient autonomy or deciding one's own fate in relation to the right to life, liberty, and the security of the person. One of the main complaints in the case of Carter versus Canada was that the Criminal Code, Section 241B and Section 14, infringed on the right to life, liberty, and security of the person. This was supported by case law, and this is why the ban on physician-assisted suicide was lifted. The court made the declaration that the Criminal Code, Section 241B and Section 14 infringed on the right to life, liberty, and security of person, and this infringement was not justified under Section 1 of the Charter of Rights and Freedoms. Therefore, these sections would be invalid. This lifts the ban on physician-assisted death for an adult who is competent and clearly consents to terminating his or her own life and has a serious and unalterable medical condition, including a disease, an illness, or disability that results in intolerable suffering to the individual. This ruling only makes the act of physician-assisted suicide legal and doesn't have any significance in the policies and standards of care that are set forth by the provincial governments and the colleges that govern physicians. In fact, in the ruling it is stated that physicians would not be compelled to provide assistance in dying, but only decrees that the criminal ban is void. Because of the ruling in this case, Bill S-22-5 has been sent to the Senate of Canada. This is an act to amend the Criminal Code of Canada, Section 14 and 241A, to reflect the ruling of the court. The amendment to Section 14 addresses consent of voluntary euthanasia by a patient that is performed by a physician and that the physician will not be held criminally liable of homicide. In Section 241, the heading will be amended to suicide and physician-assisted suicide, and many conditions surrounding the physician-assisted suicide are addressed here. That's the end of my presentation. Thank you.